Hey, good morning, good afternoon, good evening, depending on what part of the world you are in. This is Big Girl Diary. Okay, all right, all right. I have the motion to oppress P. Diddy's lawyers. And I gotta say, it is a long, it's 30 pages long. I'm like, oh, okay. So I'm gonna do my very best to go through it and to make sure that I get those parts out. But okay, I want to be fair for both sides. And sometimes it's kind of hard when somebody's so despicable. And also, I find government despicable too. So, two, it's like, which one is worse? Both are like greasy and oozy. Okay. So, let's go ahead and get to it. Let's just get straight to it. The introduction. The government has a duty of candor when it seeks warrants. The nature of the proceeding mandates secrecy, so the proceedings is not adversarial. Precisely for this reason, investigators have an obligation to present a fair picture of evidence, including both inculpatory and exculpatory facts. While investigators need not present a magistrate with every bit of evidence when they have discovered, they must nonetheless include a reasonable, even hand account. They cannot omit critical exculpatory facts that might undermine the finding of the probable cause. The Second Circuit has instructed investigators should include evidence if it is the kind of thing the judge would wish to know in determining whether probable cause exists. The United States versus Raja Raja Ratham. Okay. The government in this case utterly failed to do so. It sought several warrants to seek Mr. Combs' residence with electronic devices and with persons, and it presented a grossly distorted pictures of the facts, including only in inculpatory facts that it excluded critical exculpatory evidence that was indisputable or indisputably in the possession at the time. The government claims victims were coerced in mechs, but they failed to inform the magistrate that, you see the black mark there, it failed also to inform the magistrate that the possession or it possessed text messages between the alleged victims and Mr. Combs blank. The applications were intentionally misleading, which is which at a minimum requires a frank hearing. The warrant themselves were grossly overbroad on the theory, and Mr. Combs's entire life was a criminal enterprise. The government sought virtually limitless authority to seize every evidence related to that enterprise. All his digital devices and the information they contained in the information in his iCloud account, plus troves of records and the item in his shoes in his houses, also almost none of them which were contraband in the United States, where, oh wow, this is pretty wild. The Judge Nathan found similar warrants unconstitutional. There are here the government obtained authority to rummage at will Mr. Combs's private effects, Arizona versus Grant. Perhaps most troubling Troublingly, the government received essential limitless authority to search Mr. Combs's device, which obtained a vast trove of personal information, the United States versus Ganis. The Supreme Court and the Second Court have repeatedly warned that it is essential or is essentially important that the device searches must be limited to and particularized. The warrants here were not. The warrants were thus unconstitutional, generally warrants, and the evidence obtained through the warrants must be suppressed. Whoa. Okay, now that right there, just in itself, um, is big. So they're like, hey, go get any and everything, and by them having such a broad whatever, I can't even find a word to simply fit in this because I'm not a lawyer. I got $7.50 worth of law, as you can tell. However, from my perspective, this is going to be quite interesting, and it's going to be an uphill battle now that P. Diddy's side has an understanding of what's going on and what they have and the superseding charges that they were bringing. So let's get back to it because there is a lot more. Okay. So during the investigation, the government executed numerous search warrants. On January 4th, 2024, it received a warrant to obtain all information in Combs' iCloud accounts. On March 22nd, 2024, it received 2 warrants to search Combs' residence in Los Angeles, Mapleton Drive, and Miami, Star Island Drive. Those applications were based on substantially identical affidavits sworn by HSI Special Agent Sean Quinn. 3 days later, on March 25th, the government obtained an additional warrant to search Combs's person and to seize and to search 2 of his cell phones. The warrant sought to obtain evidence related to possible crimes of racketeering, car trafficking, and obstruction of justice. Okay, the list of the items to be seized at the residence was incredibly broad. Spanning pages, it included, among other categories, in digital devices found within the residence. The list of information to be detained from the evidence was similarly broad, but the evidence below the warrant application presented a grossly distorted picture of reality. The government had in its possession, for an example, a variety of evidence, including suggesting victim one's participating in the alleged freak-offs or FOs was voluntary and consensual, not coerced, as the government suggested in the application. The government claims blank was based primarily on a statement from producer one, an utterly unreliable witness whose claims were contradicted by other evidence that the government failed to mention, and the government's obstruction allegations were largely on text and statements taken out of context. A critical part of the text being that all these blank marks. The affidavit also failed to mention that nearly every victim had interviewed. I'm sorry, every witness he interviewed had blank giving them a financial motive to fabricate or embellish. The probable cause statements were intentionally misleading, but it worked. The government, but it worked. It worked. The government got its warrants, leaked damaging information, and then executed a military style raid at Combs's residence. Through this duplicity, the government obtained evidence including multiple electronics devices with numerous amounts of information about their entire life and the enormous and unfair tactical advantage. It continued to press and advantage, obtaining and indicting multiple additional warrants, which were so incredibly broad. So, as you can see right there, wow. Now, okay, just imagine you're doing business, right? And you have whatever what your situation is with P. Diddy, and you're doing texting and emails and all this other stuff. Everything you have said, whomever you are, the FBI knows, the government knows everything. They took his life and shook it upside down, and everything is falling out. Now, whether it's positive or negative, they got it all. And they're going to come talk to you. Oh my goodness, this is something. This is something. Okay. The magistrate can only perform that function if the government provides an accurate and complete statement of the evidence demonstrating probable cause. Under Frank versus Delaware, if a statement of probable cause contains material false or misleading statements or omission, that the warrant is invalid and any evidence obtained pursuant of the warrant must be suppressed. To suppress evidence obtained pursuant to a warrant, a defendant must show one that the warrant application contained intentionally and reckless misleading statements or admission, and two, that the falsehood or admissions were material and necessary to the warrant issuance. See United States versus Crapfield. And to obtain a frank hearing, a defendant needs only to make a substantial primarily showing as each prong, frank, reckless, or intent may be inferred where the omitting information was clearly critical to the probable cause determination. Rivera versus United States. Okay. As noted, a warrant application can be false either through affirmative false statements or misleading omissions. The application must contain a reasonable, complete statement of evidence, including exculpatory evidence that would be critical to the evaluation of probable cause. Okay. Through the officer's need, not volunteer every fact that arguably cuts against the existence of probable cause, the officer may not admit circumstances that are critical to the evaluation of the probable cause. Brown versus D'Amico. Okay. While an application needs not include every potential evocating uh, evocating detail that would intentionally a novelist or gossip to investigators. Okay. Okay, cannot make a unilateral decision about the material or information or merely inform the magistrate or the judge of inculpatory evidence. Washington versus Neapolitano. Okay, simply put, an affiant seeking a warrant cannot uh, cannot without important exculpatory evidence from the magistrate. The duty to include critical exculpatory evidence includes a duty of the real information that undermines the credibility of the information, confidential information, or other witnesses. When the government relies on witnesses' statements rather than the evidence on observation, their credibility is plainly relevant, even critical to the probable cause determination. Macaulay versus County of Rensselaer. The failure to the failure to provide known information that goes directly to the credibility of the witness or information violates the investigator's duty to disclose. The government made false statements and omitted critical exculpatory evidence in its warrant application is in this case, this omitted evidence was the government's possession of the time it sought the warrant. The omissions were intentional and at the very least reckless. Whoa, okay. The government's warrant application hid critical exculpatory evidence regarding victim one, consent, and financial motives. Now, this one is quite interesting because I believe this person is Cassie. Now, she went after him last year and got a large sum of money, and and based on that information that she gave, um, just a whole lot happened. But let me get back to this thing. Okay. Okay, the core allegations in the warrant application, and indeed the government's entire case, is that Combs forced victim one to participate in FOs. In its March warrant application, a search the residence is stated that's blacked out. This statement was based on the investigator's interview with victim one, which took place 5 years after the event. But the government's unaccountable failure to inform the magistrate, oh wow, both of which severely undermined its account when it is sought that the warrant to search Mr. Combs' residence, the government had already obtained one device from the victim that contained it's blacked out. Oh man, a whole lot is blacked out. Okay. Whole paragraph. Okay, Griegos deal. Okay. Unbelievably, the government did not blank in the warrant application or even inform the magistrate. Faced with the claim of coerced and forced mechs, the blank is the sort of thing that any finder would wish to know. This was not accidental omission. Two, by the time it was obtained the warrant to search Mr. Combs' residence, The government had reached already obtained bleep, bleep, bleep all the way through. Once again, these bleep contradicts the government's claim that the FOs were coerced. Oh my goodness. This is not good. Okay, everything is blacked out here. Oh my goodness, everything. Wow. Exit. Okay, these are the exhibits. Oh my goodness. And even the next page, it's just something. That's a lot. Okay. Okay, there are important evidence to show the context of the relationship. And they also, okay, all those bleeps right there, they are the kind of thing that the magistrate judge would wish to know when reviewing the warrant application in the Mex car trafficking case. Raj Hart, Raj Rat, them, okay, whatever. Yet the warrant application contained not even a hint of them. They didn't even inform the magistrate judge that the evidence existed. They simply stated that blank, this was intentionally misleading, blank, contradict victim one's later. Wow, all these blanks. Oh my God, it gets worse. Account that gave the investigators obvious reasons to doubt the veracity of the allegations, the United States versus Cerda. Okay, the investigator was thus legally required to disclose them. 3, blank contradicts the application in other ways too. The application said blank again, tell the different story, exhibit 18. The warrant application also claimed blank. Again, the government hid evidence to the contrary. For an example, oh my goodness, all these blanks and blanks and blanks. Okay, 26, as the government has since in conceded in the disclosure letter. Moreover, the government hid evidence that Combs at the time discouraged from using so many rugs. Exhibit 27, Exhibit 15. 4, finally, the warrant application contained no mention of victim one's financial motives to exaggerate and falsify. And the government knew blank, blank, blank all the way through, thus provided and usually strong motives to fabricate years after the underlying events. Okay, blank suggests that years after her relationship, she changed her story in a way that would cause maximum potential damage to Combs and thus give him maximum incentives to agree to a large payout. This is exactly the sort of evidence that goes directly to the credibility of the witness, whose story provided a core of the government's application. Core, McCollery. Okay. As courts as courts around the country have held evidence that undermine the credibility of the key witness must be revealed because the magistrate judge must be given the opportunity to access the totality of the circumstances. Okay. Here, rather than giving the review magistrate a fair summary, the government hid exculpatory evidence to bolster its case. The warrant application were calculated to mislead, omitting clearly critical evidence. C, the government's warrant application hid critical, okay. The government also sought to corroborate victim one's allegations to make it related allegations with statements of other witnesses and victims. Again, the government hid evidence undermining these witnesses' credibility and let me see, credibility and presented misleading and selective accounts. We are not dealing with omission of a few ancillary facts. This is the case of systematic deception. Whoa. One, MEX Worker One. The government relied on the information of MEX Worker One, all the bleeps, but MEX Worker One has also given the government exculpatory information, none of which was included in the warrant application. In December 29, 2024, discovery letters, for an example, the government revealed that bleep in excerpt 32 or exhibit 32, excuse me. These statements from a key participant in the FOs undermine the allegations that, oh man, that, and they corroborate all the blanks. It is unclear when the government received this information. The government has only stated bleep all the way through. Sometimes any investigator would have asked, it is also unclear what other exculpatory statements MEX Worker One made about bleep. That is precisely why the Franks hearing is required, to learn more about the government, what the government knew and when. However, even if the government is not yet aware of bleep, it could have been aware of it asked, given the government's loose relationship with the truth, whoa, okay, throughout its warrant application, the most obvious inference is that the government was already aware of MEX Worker One exculpatory statement that simply failed to include them in the application. It did exactly what the Second Circuit forbids, merely inform and the magistrate or judge of inculpatory evidence. Two, the assistant. The warrant application relied on information about the assistant one, including. Now, the assistant, I wonder if the assistant is Little Rod. That's what I'm wondering. This is a lot. This is a lot. And it's not like the government wouldn't do anything like this. Yeah, they can, they would, they could, and they do. Woo, man. Forgive me, this is a lot. And let's continue. Okay, the application, okay, assistant one. With victim one and the application failed to disclose that. Okay. Oh man, this is a lot. But the applications were particularly misleading in the recounting or suppress obstruction of justice. They stated Combs had obstructed justice by bleep, 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 but the government cherry picked a couple of statements out of context to imply bleep, bleep, but the complete thread demonstrates the opposite. Oh man. Okay, this was not a harassing or threatening exchange. It was rather bleep, 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 bleep. Does not remotely make out probable cause for an act of obstruction, but the government plucked a few quotes out of the context that thus presented the magistrate with a complete distorted picture of what happened. The distortion could not have been accidental. It is a deliberate choice. This is terrible. Even for him. Okay, producer one. Okay, producer one. Okay, I think this okay, Little Rod is either assistant one or I don't know. I don't know. But so far right now we're on the third person. I think the first one was Cassie. The second one or the second and third is a Little Rod and the another person in there I'm not quite sure who it could be. A producer. Some of the most salacious allegations recounted in the warrant application came from producer one, who the government now says it will not even call to testify at trial. The investigators indicated he had interviewed producer one, and producer one had a relayed story about the time working for Combs. Producer one claimed, among other things, that bleep, 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 bleep. But the most serious and specific allegation from producer one was he claimed that bleep, 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 the application state, oh yeah, this is Little Rod. These accusations were never credible. They were uncorroborated, and the government had boatloads of contradictory evidence included. The government eventually dropped these allegations in later warrants, but they lacked credibility, was manifest from the oust. And the government once again failed to disclose producer one's financial incentives to fabricate and embellish producer one's bleep, 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 bleep. Okay. The government has advised us it will not call producer one as a witness at Combs' trial. Presumably, that is because his stories are fantastical. Wow. And he lacks any credibility, but his lack of credibility is equally apparent in March 24th, in 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 part based on blah 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 blah. Um, at a minimum, the warrant application should have disclosed bleep bleep, namely his motives to fabricate and to tell the government a story that matched the stories bleep bleep bleep. Once again, however, the government had hid this from the magistrate, and the investigators simply relied producers one's claims without qualification as if he were a credible witness. Victim two, okay, well, totally bleeped out. Victim three, okay, the affidavit alleged based on the interviews with victim three that Combs bleep bleep relevance of these allegations is less clear. The claims of victim three appeared under the header. Okay. In any case, the warrant application once again included none of the information the government must have known that called into question her credibility regarding her allegations. Oh my goodness. This is getting wild. I mean, it has been wild, but wow. Okay, once again, none of the information necessary to assist her credibility was included in the warrant application. Victim four, wow. The warrant application included allegations that victim four, bleep bleep, they went on to state that bleep bleep, the government made an effort to corroborate victim four's claims if it had conducted a reasonable, competent investigation, it would have obtained evidence contradicting her statement, including bleep bleep. The application failed to note that bleep bleep. Designer one. Wow. Okay. The warrant application also included allegations from Designer One. The government also claimed the representatives of Combe had encouraged in. Now, I wonder who that designer was. Hmm. Does anybody know who Designer One is? I mean, this whole thing is wild, and I have to say, Diddy's lawyers, they do make some compelling arguments. And they do, but it's not going to work. They want Diddy. They want Diddy out. He's not bringing in any new talent, and they were grooming Drake to be the new Diddy. And just look at his behavior. I'm going to leave it alone. But Kendrick Lamar put a stop to that. Oh my goodness. Oh my goodness. Okay. The application failed to note the context of that bleep bleep. And as some three critical witnesses in which the government relied on were all bleep bleep bleep. Not only did they have a general financial motive to fabricate, the information would have, to put it mildly, raised doubts about their credibility, but the government said nothing about bleep bleep. Once again, it intentionally hid evidence that would have undermined their credibility. The misrepresentation and misleading omissions in the warrant are frequently and patterned. The affiant omitted, for an example, the information about all the witnesses, bleep, and financial motives to fabricate. The omissions were related to exculpatory, indicating recklessness. This is the case where the cumulative effect of all of the omissions was to eliminate nearly every indicator detracting from the witnesses' reliability. United States versus Simmons. This is a case where the affiant failed to provide all potential adverse information that might have undermined a probable cause finding. And the law requires oh my goodness, this is wild. And I'm almost done. Almost done. The government to include all critical exculpatory information in a warrant application. Here, the government included none. Mex car trafficking, like hidocornography, is also repulsive, a crime that those entrusted to root it out may, in their zeal, be tempted to bend or even break the rules. When the government investigation cheats on obtaining warrants, they endanger the freedom of all. In cases like this, it is essential that courts enforce their requirement of the Fourth Amendment, both to protect the individual defendant's rights and also to deter this sort of governmental misconduct. Now, I gotta say something. Now, when they talk about Hild H car trafficking, right? I did a video last year when Bad Boys and Jay-Z, Beyonce's choreographer, went down to the went down to the Caribbean, and this was back in like 2013, and they were looking for talent from the age of 3 or 4 to 45. Who knows how many people that were picked up? Now, they even got the local politicians into it to where some hands were greased. Now, let me finish this up and then I'll get back to some of my thoughts. Just fruit for thought. And please do your own investigating. Think for yourself. Okay. Okay. Government to include the critical exculpatory information in the warrant application. Here is the government including none. Okay, I already read that. Okay, when the government investigating, okay, I already read that. The misstatements and omission were material. There is no question based on the above evidence that the warrant application contained falsehoods and misleading omissions. The remaining question, the second prong of Frank's, is whether those falsehoods were material. This analysis examines when a hypothetical truthful warrant application would have stated and whether that information would have supported probable cause. In the case of misstatements and reviewing, the court must set aside the misstatements and determine whether if the tainted portions of the are sufficient for a probable cause. Rajaratnam, okay, in the case of misleading information or omissions, the court must insert the omitted truth and determine whether they undermine probable cause. Here's a truthful application would have stated that victim one's bleep bleep bleep, but also that the relationship was long, complicated, and even loving. They have stated that and such truthful presentation would not have provided probable. This is wild. This is really wild. And man, okay. Let me just say this. Victim one, person one was Cassie, and she been with P. Diddy for 10 years. And it wasn't, I'm not sure, but I have a suspicion that P. Diddy left her to get with Young Miami, and Young Miami would sit there and just, mess with Cassie. Okay, let me hold on to that. There, man, oh man. This is a mess. A huge mess. Okay. Okay, cause for the MEX H car trafficking charges or any false federal offenses. Still, less would have provided a basis to search everything and anything in Combs' 2 residence for a decade later. That's true. Truthful applications would have stated that Combs bleep bleep bleep. They would have stated that producer one bleep bleep bleep. They would have stated that bleep bleep bleep. Such a truthful presentation would not have provided probable cause of MEX H car trafficking or racketeering. Truthful applications would have stated that after bleep bleep bleep, they would have not noted, however, that nearly all of the witnesses had also bleep bleep bleep. They would have not. They would have noted that some of Combs' representatives bleep bleep bleep. Such a truthful representation I'm sorry, presentation would not have provided probable cause for obstruction of justice. The government here fortunately demonstrated a darn the torpedo full speed ahead mentality, the US versus Coonan, in its zeal to prosecute a famous target. It rushed ahead to violate the law. It submitted an egregiously false and misleading summary of the evidence, thus denying the disinterested neutral and disinterested magistrate the opposing and the independently undermine whether probable cause existed based on a fair and truthful summary of the evidence. Reisenberg, okay, it presented only in inculpatory evidence and it hid the exculpatory evidence. These facts taken the take the aggregate. Man, oh man, oh man. Okay. Were were material to the probable cause determination. Truthful and complete applications would not have provided probable cause to search both of Combs' residence and all his devices. The warrants were unconstitutionally broad. The warrant themselves were unconstitutionally broad, and the charges were reflect in extraordinary legal theory that Combs is himself the empire, and that the business, the household, the personal relationships in his Mex life were all a part of the criminal conspiracy. That a broad theory is alleged in the indictment and reflected in the warrants. The government essentially took the position that everything about his life is possibly evidence of a crime in a series of warrants, and this saw authority to search and seize anything in his iCloud account. Oh, in anything in his iCloud account, B, his residence, C, his cellular phone, and D, his hotel room. The only limitation that the evidence had to be related to the subject's offenses because but because the theory was that his entire life was a racketeering enterprise. That was not limitation at all. That was no limitation at all. This case implicates the central concern underlining the Fourth Amendment, the concern about giving police officers unbridled discretion to rummage in at will among a person's private effects. This is exactly what the warrant unlawfully allowed. The Fourth Amendment forbids general warrants. The Fourth Amendment warrants clause requires that any valid warrant must state with practicality the fact to be searched and the things to be seized. The purpose of the particular requirement was to prevent the government from using broad warrants to rummage through a person's whole life. The chief evil that permitted or prompted these framings in adopting the Fourth Amendment was the indiscriminate search and seizure conducting by the British under the authority of the general warrants. The United States versus Gopin. Okay, I'm almost done. I'm almost done. Almost done. A warrant at the minimum satisfy three criteria. One, must specify the offense. It must describe the place to be searched, and it must specify the relationship between the items sought and the designated crimes. In addition to those three general factors, there are also substantial specific considerations that bear in and that bear on legality. For an example, a warrant that fails to indicate a reasonable specific date range can be constitutionally overbroad. Moreover, the search and seizures of personal electronic devices raise additional concerns. The seizures of such devices can give government possession of vast troves of personal information that the people or that the person to whom the drive alongs, much of which may be entirely irrelevant to the criminal investigation that leads to the seizure. A cell phone search, for an example, would typically expose the government far more than the most exhaustive search of a house, because a phone not only contains a digital form of sensitive records previously found in the home, it also contains a broad array of private information never found in the home in any room, Riley versus California. Indeed, these devices contain privacies of life. The warrant seeking to seize and search personal devices therefore create serious risk that every warrant for electronic information will be, in effect, a general warrant. Gopin versus Gopin. The Second Circuit has held the warrant Jack. Warrants lacking meaningful perimeters on the otherwise limitless search of a person's electronics devices are invalid. Again, at the bottom of the core abuse of the Fourth Amendment sought to prohibit was general um, exploratory rummaging in a person's belongings. This is true as the belongings of a person's home and as to the belongings. Okay. Okay. On a person's cell phone, in this case, the government sought and received authority for general exploratory rummaging through Mr. Combs' entire physical and digital life. The government sought warrants in the case that gave the unfettered ability to search Mr. Combs' residence, its digital devices, his iCloud account, the government's list of items to be seized from his home was pages long and stunning in its breadth. The government claimed the rights to seize, among other things, evidence that Mr. Combs' location and other things reflecting the location of any conspirators, oh my goodness, or witnesses, which including the government seems to mean anything who ever worked for Combs or went to a party. Oh my goodness. Electric bills, mails, correspondence, address books, all calendars and schedule information, including travel records, all financial records, including bank statements and credit card statements, plus all cash, property, deeds, or titles, or anything related to property ownership, plus any evidence relating to online financial accounts. Oh my goodness. Any Mex toys, sexually suggestive clothing, whether that means plus any medical supplies or other materials possibly related to mechs, plus any bodily fluid or other materials that might contain DNA evidence. Oh my goodness. Wow. Okay. Wow. What a broad. Okay. All right. I'm going to keep that to myself. What a. Oh my goodness. Okay. Any communication or records of the communication with any former sexual partner or employee of Combs's business, plus any communication related to the charges offense, which was, as noted, defined incredibly broadly, with any possible victims, co-conspirators, and witnesses. The the corporate record includes corporate organizations, ownerships, documents, employee records, any digital devices that may contain evidence, including phones, computers, iPads, cameras. These descriptions were often written with scratch all clause, which with regular use of phrases such as including without limitations and including but not limited to the list above. You can't make this stuff up. Oh my goodness. This is not even a remotely complete list of what the warrant sought. It merely sets forth the high level of category targeting by the government. The government's warrant to search Combs' iCloud account and his cell phones were similarly broad as to the information it sought. The government must have just well have said everything. The iCloud warrant sought the ability to search anything stored in the accounts. The cell phone warrant, both the initial March warrants and subsequently September warrants, sought all communications, photos, documents, calendars, location data. Wow. Travel records, financial records, call records, and so on. Anything related to the subject offenses. But because the subject offenses were detained as included all of Combs' businesses, his household, and the relationships with his girlfriends over the last 2 decades, it's hard to think of anything that would not have been related to the subject offenses. Okay. In the United States versus the judge Nathan held that similarly broad warrant were unconstitutionally broad and suppress the evidence obtained through the warrants. Way involved securities fraud offenses, and the government obtained warrants to search both the residence and his place of business. The warrants broadly sought any and all records or evidence that might be related to the offenses, including financial records, bills, messages, travel records, photos, computers, and cell phones, and so on. Indeed, the broad list of items to be seized very much resemble the list in this case. The district court ruled the warrants were overbroad and therefore illegal. Several key reasons undergirded the ruling. Although the warrants generally identified the crime as security fraud, and the categories of the documents sought were so broad and numerous as to be consistent with the investigation into almost any form of financial crime. More importantly, the warrant set forth expansive categories of often generic items and subject to seizure. Several of the catch-all variety without crucially, and linkage to the suspected criminal activity, or indeed any meaningful content based on the parameters of, or other limiting principles. In way, as here, the listed property was not illegal contraband. Rather, it was property in lawful use of the government, only vaguely suggested might be related to the broad specified criminal activity. Wayne Wayne R. Lafif, Security and Siege and Seizure, the treaties of the Fourth Amendment. In way, as here, the warrant lacked any meaningful temporary limitation on the item that could be seized. At bottom, the warrant in way violated the Fourth Amendment because they authorized the seizure of sweeping categories of material and lacked any particular practical tool to guide the search agent in distinguishing meaningful between material and potentially evidentiary value, and those obviously devoid of it. As Judge Nathan concluded, the warrants were in function, if not in form, general warrants. At the same time, indeed, the warrants here are even more affirm, where the warrants in way authorize unbound search of any the defendant's business affairs, and warrants their authorized unbounded searches of Mr. Combs' businesses and personal affairs. The warrants here allowed the very sort of general exploratory rummaging in the person's belongings that the Fourth Amendment forbids. Nor can the government evade the Fourth Amendment's limited simple but stating that Mr. Combs was himself a sort of a criminal racketeering enterprise, and therefore all evidence of the business and personal life criminal. Okay. I'm sorry about that. Therefore, all evidence of the business of personal life, relevant evidence in crime, is such a rhetorical trick that allowed the Fourth Amendment would lose all meaning. So Lord Chief, this is interesting. Lord Chief Justice Holt once famously alleged or challenged a prosecutor, "Hold, what are you doing now? Are you going to arraign his whole life?" This is exactly what the government did here. It charged Mr. Combs' whole life as a racketeering enterprise, and when it obtained warrants to search his whole life. Okay, this is it right here. Okay, warrants a warrant or warrants to search his house or his hose, maybe his house, the cell phone warrants, the Park Hyatt warrants, were individually and collectively exactly the sort of general warrants that the Fourth Amendment sought to forbid. Conclusion. For the foregoing reason, this court should suppress the evidence and all fruits obtained from the warrants to search Combs's residence, his personal, his person, his iPhone accounts, his devices. This warrant or these warrants were unconstitutionally broad, and the alternative, and at the minimum, the court should order a frank hearing to hear evidence, additional evidence in determining whether the warrants were properly obtained through deception. Okay. That was a lot. We got through all 30 pages. Okay. Now, looking at that makes me look at things a little different, because it was quite interesting, and it seems like that what was stated, that everything or the government's case, is based on four people's eyewitness testimony. And when you look at what they have done beforehand, they sued and got money. Now, when you look at Little Rod, and he was a producer, and P. Diddy would fly off the handle and scream and holler, and Little Rod even suggested that he was forced to have sexual relations when he was supposed to simply be videotaping. I don't know. There's a lot there. And then you have Cassie. Cassie said that she was in a relationship with him for 10 years, but she was abused for 10 years. Oh my goodness. I got to think about this some more. This is a lot, a whole lot. So please take a look at it, and make up your own mind. Okay, regardless of what I said or read, make up your own mind. On that note, I do want to thank you for stopping by. Okay, this was a lot of work. Please, as I said, like and subscribe. And also, I am demonetized, so please, Cash App, PayPal, Venmo, Big Girl Diary. Everything helps to keep up with all of this stuff, all of these subscriptions that I have. On that note, I want to thank you for stopping by.